Let you know we can start. Still waiting for Ms. Persico's perfect. Oyez, oyez, oyez. All persons having business before the Honorable the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-3021. United States of America versus Gregory Lassiter, also known as G. Appellant. Ms. Persico for the appellant, Mr. Gurgel for the appellate. Ms. Persico is now muted.
Good morning.
Good morning, Your Honors. May it please the Court, my name is Deborah Persico, and I'm here this morning on behalf of the appellant, Gregory Lassiter. I'd like to focus on the first argument in our brief, and Mr. Lassiter's position is that the district court was not authorized to re-sentence him on the kidnapping conviction after it had vacated the 924C conviction, because his initial sentence was not a sentencing package, meaning that the 924C and the kidnapping sentences were not interdependent, and the record of the 2009 sentencing, the initial sentencing, does not show that the judge's decision when he varied downward from the kidnapping guidelines had anything to do with the fact that he had to impose a consecutive 7 years for the 924C.
If we accept his proposition that it was a packaging sentence, do you have a case left at that point?
If you accept the government's proposition that it was...
Yeah, which the judge, I think, said on the record that it had been a package, didn't he?
Your Honor, the judge said at the 2020 sentencing that he recalled. However, the problem is that if you look back at the 2009 sentencing...
That's not what I'm asking you, though. I'm asking you if we accept that proposition. I know you're saying we shouldn't accept it. I understand that. But if we accept that proposition, do you have a case left at that?
No, I do not.
Okay, so that is essential.
That is essential. You have to find that there was not a sentencing package. And I'd like to go back to your comment about what the judge said in 2020. Okay. The problem is, and our position is, that the judge just misrecollected what he had done in 2009.
Well, wait, before you say that, let's assume you're right that we have to find it in the first sentencing. This is plain error review, so your burden is pretty heavy. The government points to two things in the record to indicate that the judge, to confirm what the judge said later, namely that this was a package sentence. They point out that at the original sentencing, the judge addressed the defendants collectively before imposing the sentence, and then he referred to the sentence in the singular. Now, those are not the strongest signals. I take that. I give you that. But this is plain error review. And why isn't that enough, particularly since, as Judge Sentelle pointed out, at the second sentencing, the judge was very clear what he had done.
Well, at the second sentencing, he said that that's what he had intended 11 years previously. Right. But when you look at the sentencing transcript, the judge's sole focus, and look at all of the defendants' sentences.
No. But what about the two points that the government points to in the record here?
2 points where
that the judge referred to. He referred to defendants collectively, and he referred to it as a sentence.
What he was referring to was the kidnapping sentence. And if you look at the transcript, his sole focus in sentencing each of these defendants was in crafting a proportionate kidnapping sentence that was based on each defendant's conduct during the kidnapping, each defendant's level of cooperation, and each defendant's criminal and personal history. There is not one time in any of those sentencings in 2009 where the judge says, and I will also take into consideration that I'm going to have to add this 7 years mandatory minimum. In fact, what he says is that I'm going to create this proportionate sentence on the kidnapping guidelines, and then I'm going to add 7 years. He never connects the 924C sentence with the kidnapping sentence, and the entire discussion at each of the sentencings involves solely the kidnapping conduct and then each defendant's level of cooperation and their criminal history category.
Can we assume, counsel, that when a judge exercises a downward departure for one of the crimes, and let's assume they are related, that the judge is reaching for an overall sentence package? Can we just assume that when there's a downward departure on one of the crimes, and he did depart downward on the kidnapping?
Your Honor, no, I don't think that you can assume that. And if you look at Townsend and you look at your Smith case in 2006, you see that the court specifically relied on what was in the record, not simply that there were a number of sentences and it ended up being a certain total sentence. The court has looked at the record to find out what the judge's intent was. So in other words, in the Townsend case, this court pointed out that the record explicitly showed that the judge relied on a sentencing package theory.
Does that mean that that becomes a requirement, or simply that that was an appropriate way of explaining what happened in that case?
Well, I believe that it becomes the standard, because not only was that the standard in Townsend, but in Smith, this court repeated that same standard. And it looked at the record, and it told, and in Smith, the defendant challenged the sentence, and this court said, the record is conspicuously absent any sign of a sentencing package. And so our position is that based on Townsend, based on Smith, that this court has to look at the initial sentencing record. And while the judge may have thought that he did something in 11 years prior, the fact is that when you look at the record does not support that. And
Lassiter's record was dreadful at the time. I mean, he was really a bad character.
Yes.
Yeah.
And so why would the judge exercise downward departure on the basic crime of kidnapping?
Because Mr. Lassiter cooperated, and the government told the judge that he was either the first or one of the first people to come in and cooperate. And in addition to that, Mr. Lassiter had a number of mental health issues that the judge took into consideration. Those were the reasons that he departed downward, and that Mr. Lassiter still ended up with the highest sentence among all of the co-defendants, because his behavior, according to the judge, was the most egregious. That's how he got the downward departure.
You wouldn't disagree with that statement about how egregious it was, I'm sure.
No, I don't disagree with that.
Okay.
Does the court have any further questions? Okay, thank you very much.
Thank you. We'll hear from the government.
Good morning, Your Honor, and may it please the court. Kyle Griegel on behalf of the United States. Your Honor, Gregory Lassiter received a sentencing package, and for that reason, the district court could, following the vacatur of his 924C count, resentence Lassiter on the predicate offense of federal kidnapping. Lassiter never contested that view during his initial resentencing, and to the contrary, leaned into it, asking affirmatively the district court to take stock of his subsequent rehabilitation in assessing his new sentence. Only now on appeal, after that strategy came up short, has Lassiter changed his position. But the district court did not err, and certainly didn't plainly err, in its recollection that a sentencing package was originally appropriate. Our position is that this case is largely resolved simply by an application of this court's prior decision in Townsend, which notes that as a general matter, when sentencing on a multi-count indictment, there is a strong likelihood that a sentencing package is intended, and that is especially so in cases involving 924C counts
Right, but Townsend still requires that we find that it was in fact viewed by the judge as a package, right? Just because it's a 924, just because there's a 924 count doesn't mean it's a sentencing package.
I think that's correct, Your Honor. The last paragraph.
What do you think? That's what Townsend says.
Your Honor, the last paragraph of Townsend leaves for another day the question of what to do with a case where there is no indication in the record or where there is evidence to the contrary that a sentencing package was intended. But we don't believe the court needs to wade into that particular thicket.
Here's what Judge Sentelle said. He said, we hold only in that case where the remaining counts are closely related and the judge indicated an intention to do the packaging. So we have to find that in the record. We have to find in the record that the judge in this case, as in Townsend, intended a package sentence, right?
In order to stay within the bounds of Townsend, that is correct, Your Honor.
I'm only asking you the question because you started by telling us the case was controlled by Townsend, right?
Absolutely.
Okay, so what I quoted, what's the best evidence you have from the original sentencing that the sentencing judge viewed this as a package?
Your Honor, I believe the most persuasive piece of evidence is the side-by-side comparison of the actual sentences received by each individual defendant. I think this is a case where actions speak louder than words. Mm-hmm. Specifically, Davon Hebron received the single highest kidnapping sentence, of course, setting aside Lassiter, and the only explanation for why that could be the case is that he was the only one of those defendants to not also have a 924C count. Lassiter attempts to explain that away by noting that Davon Hebron perhaps cooperated less than the other defendants. There's simply no indication in the record to support that that's the case. In fact, on appendix page 148 in the government sentencing memorandum, the government specifically notes that even accounting for cooperation, Davon Hebron still deserved the lowest overall sentence as compared to Lassiter, Cooper, and Deborah Hebron.
You said there was another point. There are 2 points you were going to make.
Oh, absolutely. One other point first. So Lassiter notes that cites some language indicating that Davon Hebron was especially uncooperative on appendix page 150. That is as compared to McCauley and Wheeler, who were the two defendants who received 5K 1.1 letters. Nobody ever argued that Davon Hebron was less cooperative than Cooper, than Deborah Hebron, and then Lassiter. So setting aside the proportionality, we also think that the district court did make some statements that are fairly strong evidence, which Your Honor cited. So those are.
Go ahead and repeat those, please, for the record.
Absolutely, Your Honor. So one is on appendix page 268, and that's a discussion during Deborah Hebron's sentencing, in which the district court referenced the total package, and the number provided included both the kidnapping count and the 924C count. Similarly, on appendix page 333, that's during Cooper's sentencing, the language overall sentence, which is in reference to, again, the combined count. And so there does seem to be affirmative indication.
In the first statement you referred to of those two, the first statement, did the judge use the word package?
No, Your Honor. The word.
Say?
I'm sorry, Your Honor?
What did he actually say?
Oh, so that in the initial one for Deborah Hebron, there's a discussion of whether a total sentence of a certain amount there, the number thrown out was 15 years, would be appropriate. We cite that not because the district court affirmatively used the word sentencing package, but because they're indicative of the fact that the district court thought of the total amount of punishment he was assigned.
But he did not ever use the word package in the initial sentence.
That is correct, Your Honor. That language doesn't appear until resentencing, although we would, of course, note that the same is also true in Townsend, and that this court has never required talismanic language in order to apply a sentencing package theory.
How much significance do you attribute to the downward departure for Lassiter on the kidnapping?
Your Honor, we think it's a significant factor. This court in Townsend cited to the 11th Circuit's decision in Watkins discussing the fact that a sentencing package theory is especially likely to apply where the district court goes below the guidelines range. It would be very unusual for these individuals to receive the magnitude of downward variances that they received, but for the fact that the district court was taking stock of those 924C counts also. And certainly, Your Honor, we'd say it's especially compelling when held side by side to Davon Hebron, who did not have one of those 924C counts and ended up receiving a longer sentence on the kidnapping count than Cooper and then Devereaux Hebron. That simply could not be explained on any other basis than the 924C count, given their criminal histories and just the substantially greater culpability of the other two co-defendants.
Judge Sentelle, Judge Silberman, any questions?
No further.
Do you have anything more you'd like to add, or are you done?
I think that's everything, Your Honor. Thank you.
Okay, thank you. Ms. Persico, I think you saved a minute or two for rebuttal.
Yes, thank you, Your Honor.
Mm-hmm.
Okay, thank you. First off, let's go to Devon Hebron. Mr. Griegel says that there was no indication that he didn't cooperate. In the government's sentencing memo, they say Devon Hebron, who played a significant role, quote, manifested a willingness to participate in murder, quote, steadfastly refused to cooperate, and should receive a sentence greater than that of Macaulay and Wheeler. That's why Devon Hebron received such a large kidnapping sentence. He did not cooperate. Everyone else had some level of cooperation. For two of the co-defendants, Wheeler and Macaulay, the government filed a 5K 1.1 letter, but not for Lassiter and Cooper, and I believe it was Devereaux Hebron. So the judge took into consideration everyone's conduct, and he talks about this during the sentencing hearing. The government goes over everything that each defendant did during the kidnapping, and then each defendant's level of cooperation, each defendant's criminal history category, and that's how the judge comes up with a sentence for kidnapping. And again, if you look at each of these transcripts, in Devon's sentencing transcript, the judge says, I look at the broader picture of how all six co-defendants are interrelated. The co-defendants are interrelated in terms of their conduct and their cooperation in shaping a variance. And what he says, practically the same language, this is in our briefs, I've detailed this in our briefs. He says practically the same language in every other sentence. And not once does he say, and I will also take into consideration the fact that I have to, slap on another 7 years for 924C.
Counsel, let me ask this question.
Mm-hmm.
Turning to focusing on why the judge sentenced the others as they did, there's two possible interpretations. One is that the one who got the highest kidnapping did not have a 924C, and he got the highest one because of the 924C question. That's the government's argument. Your argument is no, it's because he didn't cooperate, right?
Yes.
So there are two possible interpretations. Now, if with the scope of review being so limited for plain error, don't we have to take into account the government's position there? Because, granted, there's two possible interpretations, but if there's two possible interpretations of how he sentenced the other and Lassiter, why with plain error review don't we have to accept the government's interpretation?
Your Honor, there are not two interpretations if you look at the transcripts and see the progression of how the court sentences each of these defendants. The court's sole focus is on that kidnapping. The court was only looking at what each defendant did, who had the baseball bat, who had the box cutter, who had the gun, who did what. He was solely focused on the kidnapping. So there aren't two interpretations, because at the end, at every sentence, he says, I'm going to consider everything that you did during the kidnapping and come up with a guideline sentence, and then I'm going to add 7 years for the 924C. So our position, again, is that the record is clear, it is plain, and if you follow Townsend and you follow Smith, the original sentence was not a sentencing package, and the judge did not have authority to re-sentence Mr. Lassiter on the kidnapping count.
Anything else, Larry?
No.
Okay.
Thank you, Your Honors.
Okay. Ms. Persico, you were appointed by the court to represent the defendant. You've done a fine job, and we appreciate your assistance.
Thank you very much, Your Honor. I appreciate that.
May I add, I was enormously impressed with your brief.
Yes.
Thank you so much.
Yes.
I would say it's a pleasure to have a criminal in which both parties are so well represented as in this day.
Thank you very much. I appreciate that, Your Honors.
As an old criminal lawyer, I feel good about that. Next.
Case number 20-1234, Telesat Canada et al. Petitioners versus Federal Communications Commission and United States of America. Mr. Furry for the petitioners, Ms. Smith for the respondent.
Thank you. Good morning, Your Honors. May it please
Good morning.
I'm sorry.
I said good morning.
Oh, okay. I'm Ken Furry. I'll be speaking for the joint petitioners this morning. In the order before you, the FCC has abandoned its long-standing view that Section 9 of the Communications Act permits it to assess regulatory fees only upon the satellites that it licenses. We hope and expect that the court will conclude upon review that its newly expansive view of its Section 9 fee authority does not comport with the statute. Now, the government would have the court believe that this is a cookie-cutter case of an agency interpreting its organic statute. It is not. What we have instead is the FCC doing an unlawful U-turn on its heretofore...
Unlawful is your assumption. That's what this case is about, counsel.
I'm hoping you're going to agree with me by the time I'm finished, Your Honor.
You would have to agree that it is possible for an agent to lawfully change its position on its interpretation of the statute, would you not?
Sure. It is possible. That's not what happened here.
Well, that's what we're here to decide. Now, if that's the case, that the agency did in fact lawfully change its position, and this were before us as an initial matter, do you have an argument that this would be an unlawful interpretation, or is this unlawful simply because it's a change of position?
Well, I would say both, Your Honor. I mean, there's two.
Let's deal with the one first.
Okay, which you want to deal with?
We know that you're saying it's an unlawful change, but if the first interpretation had never been there, if this were just the first interpretation the agency has made, do you have an argument against this interpretation?
Yes, Your Honor, we do. It's you would be approaching this under a sort of a Chevron step 2 kind of analysis,
exactly.
Right? So the agency in this case has changed its, again, I'm not arguing about the change of position, but the change is based solely on its new interpretation of the 1993 conference report. There's a lot of other...
Not the conference report. We're talking about the statute. Judge Sentelle asked you about the statute. And if I could just refine it a little bit, it seems to me for you to prevail at Chevron 2, you have to convince us that the FCC's interpretation of the statute, namely that it authorizes it to impose fees on satellite operators that are not U.S. licensed. That's my question. Mm-hmm. You have to demonstrate that position is, that interpretation is unreasonable, and you can't start with the legislative history. You've got to start with the language of the statute.
That's fine.
Okay.
So the language of the statute, I think we all agree, doesn't get you very far, because all the statute says is it creates a payee category for space stations.
Yeah, but it has a section called exemptions or exceptions.
Exceptions.
And as we said in Pan Am Sat, you're going to find an exception in the statute. You would expect to find it in 9E. Not there.
But you don't have to get to exceptions when you're talking about the basic authority of the commission to assess the fees, just like in ComSat, where they said the FCC couldn't come up with a fee category for unregulated railroads or people eating ice cream. It has to have an initial grant of authority to reach the entities it's trying to assess the fees from. So here the statute just says space stations. That's it. And it doesn't in any way limit what that is. That could be on the most ridiculous level, every space station around the Earth. Nothing in the statute says it's not that.
Space stations, it lists two kinds, near Earth orbit and geosyncratic, and they have to be satellites. They have to be operations that impose costs on the commission, right?
Yeah.
Right.
So it's not just any satellite anywhere on the planet.
Well, okay, right, but there are a lot of different ways you could split that baby. It could be space stations.
That's what gets us to Chevron 2. If there are a lot of different ways you can split that baby, that's what gets us to Chevron 2. Don't you have to show us why it's unreasonable to make the baby split that they've made here?
Fine, but I'm conceding that the statute doesn't get you to the answer. But Chevron allows you to look at the structure of the statute and the legislative history. And that's, in fact, what the
structure here imposes the fees based on cost. Costs are generated not because of licensing, but because of operation in the United States. So why doesn't that lead us to think that not only this is an acceptable interpretation, but perhaps even the best interpretation?
Well, first of all, Your Honor, I mean, there are lots of entities that impose regulatory costs upon the agency that are not assessed regulatory fees. That's beyond doubt. There are lots and lots of entities.
It's also beyond doubt that the agencies under this particular statute are paying, the agency under this particular statute is receiving fees based on cost. Never mind that there are lots of things in the world that are regulated that aren't fee paying. We're dealing with this particular statute and these particular facts. And so why isn't it reasonable for the agency to operate on that basis when it determines who it's going to charge the fees to?
Well, because, again, I would get to Congress has spoken to this issue, and you can see that if you go through the entire Chevron analysis. I'm sorry, Judge Silberman.
Excuse me. Let me go to your legislative history. You're looking at particularly the language that the committee intends back when originally legislation was passed. Look at that legislative history you rely on. Why is there a last sentence? These will not be applied to space stations operated by international organizations. Why is that sentence there?
Well, that's actually a good question, because as this court pointed out in Pan Am Sat, the international organizations were exempt already under the International Organizations Immunities Act. So in a sense, that the commission's new interpretation trying to say that all of that legislative history is simply about the NGOs.
Well, you're not following my question. Here's where it looks to me that even the legislative history is ambiguous. The last sentence combined with the second sentence seems to have implied thus. Therefore, these fees will apply only to space stations directly licensed by the Commission under the Act. Thus, fees will not be applied. I'm adding the word thus. Thus, fees will not be applied to space stations operated by international organizations. That can be read as the second sentence and the third sentence are connected. In other words, the Congress was only focusing on the international organizations.
Right. And that is the commission's.
If that's true, then the legislative history was silent with respect to space stations licensed by foreign countries.
Right, and that's the government's.
If the legislative history was silent on your issue, then the statute is even more appropriately interpreted by the commission.
But I don't think that's the correct reading of that legislative history. As I was going to say, the international organizations were already exempt. So
why
since that was duplicated to begin with.
So why did Congress have that last sentence?
And then the commission wants to say that both of those sentences are only about the NGOs. So it's surplusage on top of surplusage at that point.
Well, there's no rule against surplusage in legislative history. I mean, you've got, the statute has to stand. The legislative history, if the statute is interpreted reasonably, the legislative history was never enacted by Congress. The statute was enacted by Congress. So
Indeed.
who cares if there's surplusage in legislative history? There's often surplusage in legislative history just because some congressman wants to get that statement in the record. Our former colleague, who was a former congressman, used to say that he went around making up legislative history in order to have it there when you needed it later.
Well, even at that point,
the problem with the legislative history, I think, is ambiguous itself.
Yeah.
But it does not. There's no hook, as we've said before. There's no hook between the legislative history or your interpretation of the legislative history and the statute.
There is. It's entirely consistent with the entire structure of the statute, which was the one originally passed by Congress only applied fees to entities that the FCC directly licensed or authorized. And that's exactly what the legislative history says, is they're entirely consistent. We mean when we say space stations, only those authorized by the FCC pursuant to Title III.
Well, okay, even if you're right about that, let's assume you're right about that. And I like Judge Silberman, I'm not persuaded, but just assume you are. The commission says, well, that was a totally different situation. We now have, there were very few, if any, privately operated satellites not licensed then. Now there are. The circumstances has completely changed, and so we're no longer governed by conference language that dealt with a different circumstance existing in satellite technology.
Well, again, first of all, I'd say that the circumstances haven't changed dramatically or materially since 2014, which was the last time the FCC decided it didn't have jurisdiction. Mm-hmm. And they haven't changed since the further notice of proposed rulemaking in this very proceeding, in which the FCC seemed to assume that its prior construction was correct and that the only way it could reach non-U.S. licensed satellites was via some change that happened in Ray Baum's Act. It was only at the 11th hour that they came up with this brand new theory. Oh no, we've gone back and looked at legislative history from 30 years ago, decided we interpreted it incorrectly 25 years ago, and now we have a new view of what Section 9 has always meant, apparently, that we were supposed to be applying regulatory fees to non-U.S. satellites. Meanwhile, Congress...
Excuse me, Counsel. We're referring to your shock on the change on the legal theory as being inadequate notice under APA. I saw what I would call the NPRM, and the agency specifically made several statements looking to general questions as to whether or not the foreign licensed satellites should be charged regulatory fees. They put that general question out. To be sure, they said, did the Ray Baum statute alter the situation? But they had several times looked at the general question. So you were in notice that they were trying to figure a way to interpret the language of everything to allow them to impose fees on foreign licensed satellites. So you were on notice on that. And it seems to me any lawyer would have realized they had been several times reaching for the proper theory. So you were, it was broader than Ray Brown.
Well, no lawyer that actually commented in formal comments thought to go back and argue about what the 1993 conference report meant. That had been a given for almost 30 years at that point, 25 years. It was not, nobody thought that was an issue.
Well, except that the agency had several times been looking to see how they would get around the original interpretation of the statute.
Well, to be sure, that's true. I mean, this was clearly an ends-driven decision. They wanted to be able to apply these fees to foreign licensed satellites.
So you
would just make it a pure guessing game then if it's like we're going to make the most general statement and you've got to think about every conceivable argument, including those that have been decided for 25 years and accepted as the given construction of the statute.
Nonetheless, assuming that they have or haven't given notice, they've legally said enough to get this done in this rulemaking. So you're still stuck with the problem that you have. This interpretation by the agency seems to be consistent with the language of the statute. All the rest of this, you're not hurt by any lack of notice. You have every chance you need now to make the legal argument. You're talking about legal arguments. You have all those chances now. It didn't hurt you. You didn't think this notice was adequate.
I would agree we have everything we need now, and I agree the court should make the decision and tell us what Section 9 means. I would like to have had a chance to talk about reenactment because I think this is a classic reenactment case. But I see my time has expired.
Yeah, you're well over, and unless either of my colleagues has any more questions, I think we'll hear from the commission.
Thank you, Your Honor.
Okay.
Good morning, Your Honor. Pamela Smith for the Federal Communications Commission. I first want to start out and with Mr. Fareed's statement that no parties filed comments regarding the Commission's prior interpretation of the legislative history for Section 9. In particular, Petitioner Telesat filed formal reply comments, specifically opposing those comments that maintain that the Commission has had authority to impose regulatory fees on space stations that are directly authorized by the Commission to access U.S. spectrum and provide satellite service in the United States ever since Section 9 was first enacted. Section 9 provided the Commission with a specific authority to assess regulatory fees on space stations that are in geostationary orbit and space stations that are in non-geostationary orbit. Those are the only two categories. The space stations petitioners, they operate in the United States and provide service in the United States under authority that is directly granted to them by the Commission. No space station, whether domestically licensed or foreign licensed, can operate in the United States and access U.S. spectrum except as authorized by the Commission. Therefore, the Commission lawfully exercised its authority under Section 9 to amend the schedule of regulatory fees to include non-U.S. licensed space stations that have been granted U.S. market access as payers of the Commission's registration.
Counsel, do you agree with your opponent that our interpretation of the statute is based on the assumption it's ambiguous and we are therefore at Chevron step 2? Do you agree with that?
Yes, It can be I'm sorry. I think
the easy answer. I think the easy answer.
Chevron step
Yeah, I think the easy answer.
Because the statute is clear.
The easy answer to Judge Silberman's question for you, I think, is that in your brief you don't argue Chevron step one. You say the commission's interpretation is reasonable. That's your argument, isn't it?
All right.
The commission's
In fact, that's the
Yes.
title of the section, I think.
Yeah.
That's what you title your section?
Yes. The commission's interpretation is reasonable, and looking at the legislative history and concluding that legislative history does not act as a bar to imposing regulatory fees on market access grantees.
Why do you dismiss the legislative history? It's because do you read it as focused really on the international organizations only? That is the interpretation of the two sentences together? Or do you say that the legislative history is irrelevant because it doesn't, there's no hook tying it to an interpretation of the actual statute? Which is the position? Or is it both?
In this context, it's both, because previously the commission based its decision not to assess regulatory fees on non-U.S. licensed space stations, and the reason it did so was rooted exclusively in the legislative history, not in the statute, and now the commission could not reasonably have.
In your brief, you argue that the focus of the Congress, even on the legislative history, was not to touch international organizations, and implicitly that's what you are interpreting the second and third sentences together, even if you look at the legislative history. But as Judge Sentelle points out, there is no connection. First of all, even if you look at the legislative history, there's no connection, there's no hook, as we've said before, between the petitioner's interpretation of the legislative history and any language in the statute. It seems to be sort of freestanding.
That is true, Judge Silberman, but the commission interpreted that, it looked to that legislative history in the context of there being only two types of satellites when Section 9 was enacted. There were only satellites that were directly licensed by the commission, or there were these international satellites that were not directly licensed by any country. And those satellites operated, those satellites were subject to the International Organizations Immunities Act, and they were not, and their operations in the U.S. were only indirectly regulated by the commission.
Don't reject too hastily the proposition that perhaps we ought not to be looking with much favor on legislative history at all. The words of the statute, as enacted, are controlling, and your interpretation of them has to be reasonable, regardless of the legislative history, doesn't it?
Yes, and the commission's interpretation is reasonable.
Thank you.
Unless the court has any other questions, the commission requests that the petition for review be dismissed as to petitioner Canales, and then otherwise denied review of the commission's lawful exercise of its authority to amend the schedule of regulatory fees to include market access grantees that's paid.
What's your reaction to Mr. Ferrier's argument that the Commission's interpretation, Commission's new interpretation of the legislative history is just a last-minute brainstorm they had that A is suddenly new. It just come up and nobody had any notice about that.
That is an unfair characterization of the proceeding below. The commission did not decide just in this, did not review this issue just in this proceeding. The commission has reviewed this issue since regulatory fees were enacted. And this was only the latest time that the commission sought comment on whether or not it should apply regulatory fees to market access grantees.
You did.
I'm sorry.
Your notice of proposed rulemaking specifically said we're looking to whether or not we have legal authority to impose regulatory fees on foreign licensed satellites. You said that openly in your notice of proposed rulemaking.
That is correct.
So you should focus on that.
And
although you specifically referred to the Ray Baum statute, you did put the general question up: do we have legal authority to impose regulatory fees?
That is correct, and the commission actually dismissed comments regarding the Ray Baum Act as irrelevant to the issue of whether or not the commission has authority under Section 9 to assess these regulatory fees.
Okay, thank you.
Thank you so much.
Mr. Marie, you were out of time, but you can take a minute if you'd like.
I just have 3 quick points, Your Honor. I mean, first of all, I would point out that this court in the Pan Amsat case treated Title III as being coterminous with the FCC's fee authority. For better or worse, that's what the court did in that case. I think that was the right approach. I note again that the commission has referred once again to a Section 9D amendment. It is claiming that this was a 9D amendment, the action in the report and order. I don't think you can just use that as an Orphic incantation and do whatever you want. If you're the FCC, create new categories out of whole cloth. And finally, my opposing counsel just made the point that the market was quite different in the early 1990s. We wouldn't dispute that, but there were instances of non-U.S. satellites providing service at the time, and it was official U.S. policy to facilitate the expansion of that kind of service. It wasn't any kind of surprise to anybody, and indeed the contemporaneous FCC, roughly contemporaneous with the Congress that passed this act, looked at it and said, yes, what Section 9 means is fees applicable only to Title III space stations.
Thank you.
Thank you, Your Honors.
Thank you both. The case is submitted.
This honorable court is now adjourned until Tuesday, April 20th at 9:30 a.m.
Goodbye.